I'm going to take the prerogative of the moderator and ask the first two questions, and then we'll open it up to questions from the audience. I think we have a really unique opportunity here to raise some questions about Rahimi, because we have Professor Beck, who has intimate knowledge, both factually and legally, regarding the case and the issues. You know, he studied this case probably as much as anyone. And so I'm going to ask Professor Beck, I'd like the other panelists to comment as well, but I'm going to ask Professor Beck to remove his advocacy hat, because now he's a member of academia. I'm going to ask him to place his academic hat on, and to highlight for us, you know, maybe not his prediction on the result, but his prediction on maybe what the critical issues are that are likely to be the focus of oral discussion, advocacy at the hearing on Tuesday. And with that, I'd just like to add as a preface, I mean, was domestic violence even a crime, you know, during the framers? I mean, was it a crime for a spouse to beat his spouse, a female wife? And if not, then apparently there's no history or tradition that would restrict or ban the use of a firearm by such person. And then we turn to the next issue, which is, well, what's the analog? Is there even any analog that we can turn to? And if there's no analog, then I guess the government loses, and Rahimi wins. I mean, is that what's likely to happen?
Well, if I had to make a prediction about this case, I've kind of been all over the place on it. I do think that the justices are less concerned with some of the issues that we've talked about here than we think. The Fifth Circuit would never have struck down 922G1, at least definitely not as to a violent felon. The Fifth Circuit didn't hesitate a whole lot on 922G8, perhaps because of the context in which it was enacted. But you know, I've kind of got to get outside of my kind of liberal brain thinking about, well, no one could possibly go along with this, and recognize there's people in the U.S. Supreme Court that think a lot like the people on the Fifth Circuit. I'm not saying it's a good thing at all. You can make up your own mind on that. But they're going to do it, whether we win or lose, they're going to do it in a way that protects felon in possession. Of that I'm confident. And it may be that you have to have kind of a weird coalition in the majority that it might even require having Rahimi win to then limit, probably in a concurrence, the test of Bruen in order to protect felon in possession. I think there's a couple ways of doing it. I think one of the obvious dials that everyone's talking about is degree of abstraction when you're looking at historical analogs. They can always turn that a few notches one way or a few notches the other, saying they're not changing Bruen, but they're clarifying Bruen, right? I think this is all going to be couched just clarifying just how Bruen clarified Heller, which didn't answer any of these questions, right? The other thing they could do is say that we're clarifying that law-abiding is part of the test. Bruen, all of the cases talk about that concept. It's hard to know what to do with it, because when Bruen articulates its test, it's not part of it. But it can't kind of just be doing nothing in those opinions. And so that's a difficult question. They could clarify that law-abiding, and then they could do so in a way that say, even if Rahimi wins, we're kind of defining law-abiding as if you've been convicted of a felony, then you're definitely not law-abiding. However else we're going to define it, we know that's on one side of the line. So I actually think I'm more optimistic than my colleagues on Zaki Rahimi prevailing. I think what's the elephant in the room, and I know we're talking about domestic violence, it's not a statute that's used hardly at all at the federal level. But the elephant in the room is felon in possession. That's what every question the justices ask, that's what they're really asking about. And I think they're going to protect it. I think Alito might not care about G8 at all. I think he really cares about felon in possession. And so I'm just very curious as an observer to see what happens.
I'll ask Jason and Kelly if they want to comment.
Well, the two notes that I wrote were things that Professor Beck just wrote, or just said, but I really, for me, I think the huge part of the game, let me take one time out. I forgot one thing to say in my official remarks that I do have to say under departmental policy. I forgot to say that I'm here in my individual capacity. And that anything I say doesn't necessarily represent the department. So thank you for giving me that opportunity. But I think the real money is on the law-abiding versus non-law-abiding. And if you read the Solicitor General's brief, they talk about how, hey, in every other opinion, you mention the word law-abiding as if it has some sort of term of art. Please mean what you say. Please mean that there is that divide between, yes, we can regulate those who are not law-abiding. Now, but that raises a very interesting question, and I would love to have people's reactions to it. You know, do we know of any other constitutional right that works that way? In other words, you know, think about First Amendment issues. You know, do we have somebody that's a prior felon that they can't speak on certain issues? You know, does that translate to other constitutional rights? Yes, there's sort of a limitation on voting. So yes, there's kind of some semblance of that going on, but it would be a very unique thing, I think, to reach that result. But maybe they do. And I know the Solicitor General is pushing for it, and I think what we saw in Daniels was, as soon as the law-abiding part falls down, and in Daniels they rejected that, once you get into the historical test, there's just a paucity of historical analogs there, and so it just falls down. So I think the big money is on, does law-abiding mean something, or does it not?
Okay. Kelly?
I'm sort of scared to make predictions. I don't want to be too optimistic, and I don't want to be too pessimistic, but I do think there is an opportunity to sort of determine where law-abiding plays into this. I think it's very troubling, perhaps, to make a distinction between criminal convictions, which are permissible to regulate firearm possession, versus civil actions where it's impermissible. And if you look to many of the historical laws that the government cites, that we cite, they're not necessarily criminal. So like prohibiting people who refuse to swear oaths of loyalty, those were people who were convicted of crimes, but they were found to be people who could be disarmed. In the same way that people who were subject to surety statutes would have firearms regulated, despite that being a sort of civil criminal process. Not being an historian, I will borrow from somebody who is, and perhaps risk being corrected, that there wasn't sort of the same bright line distinction always at the time of the founding between civil and criminal, sort of a lot of hybrid interactions there. But then also, from a practical standpoint, a really troubling idea that, as the Fifth Circuit says, instead of a restraining order, we should be prosecuting and incarcerating everybody. If the Zaki Rahimis of the world are that bad, shouldn't we just be locking them up? Which, I think civil restraining orders, particularly in the domestic violence context, play a really critical role. Prosecutions can take a while. What do you do in the meantime? And that time of separation is oftentimes the very most dangerous as people are preparing to leave, to get out from under the immediate control of an abuser. And so this is not necessarily a Bruen argument or a historical argument. I just find it personally very troubling.
Okay. Actually, I think I'm going to hold off on my second question. We've got a little over 15 minutes left for this panel, and I want to make sure that there's plenty of opportunity for the audience to ask questions. So let's begin. Go ahead. And why don't you state your name and maybe where who you represent, and then is the question for any one member of the panel or for all members of the panel?
I'm Christina Mulligan. I'm from Brooklyn Law School, and I would love to hear the practitioners weigh in on a disagreement I had with Rob last night at dinner, which was we were talking about how, I was saying, and then Bruen says, you gotta find an analogous statute, and Rob says, no, it doesn't technically say that. It says it needs to be consistent with the historical tradition, and so you don't absolutely have to find an analogous statute. And I think, sir, my sense is that universally, everyone has read it as though you have to, and so from the practitioner point of view, I'm curious if, in your view, it is required by Bruen or not.
Does analog require a statute or just a ban or prohibition, even if it wasn't codified in statute?
So I very much enjoyed your paper, by the way. I just wanted to comment on that. And I share many of your, I was persuaded by many of your critiques of originalism and how it kind of excluded certain voices. I don't think it requires a statute. I think kind of the form of originalism that it seems like Bruen is latching onto is what really matters is what the text of the Constitution says. And then we look to other sources to either confirm or reject a presumptive interpretation of that text. So that could be done in the form of laws, right? But then we would still need to know, even then, how those laws were enforced, how often they were enforced, kind of like some of the work some of the other folks were doing. That can be done also in the form of debates that happened. I think debates were certainly cited multiple times by the government. Even in their reply, a new debate I hadn't seen before in Congress. That could be in the form of even speeches, anything that reflects an understanding of what the scope of this right was at the time to either confirm or reject what the text seems to say. That's what I think Bruen requires. I don't think it requires a specific statute, but who knows? I don't have any confidence in anything I say, by the way.
Could common law serve then? Is that check and balance? Is that?
I think certainly.
I think it could as well, right? Yeah.
It could. I'll just say, from my experience, for most of the judges, they require a law. Debates are all fine and good, but they say, well, look, you debated it, but somebody voted on it, somebody enacted it, that I can get behind. It's interesting.
Yes, sir.
My name's Tony Hockle. I'm from the California Department of Justice. I was wondering if anyone on the panel had an opinion as to whether it's better, from your perspective, to be litigating these cases in the context of a criminal action, like the Rahimi case, or like a straight-ahead civil lawsuit, like brought by an interest group, for example, again challenging the constitutionality of a state statute or a federal statute.
Like for the NRA, for example?
Yeah,
the
so
NRA's bringing the
I'm
lawsuit?
just struck by,
Yeah.
so I'm here with my colleague, Chris Rosenberg, and we have like 46 active Second Amendment cases in California that we're dealing with, and they're all civil lawsuits, where they're individual plaintiffs or often interest groups or gun dealers or manufacturers. Those are the plaintiffs, and we're the defendant. And that creates a very different dynamic and a very different day-to-day situation as compared to Mr. Bettinger, prosecuting a case where someone like Mr. Beck is defending the defendant and challenging the regulation. Is it better to make inroads for your position in one context versus another? I don't know if you've ever thought about that.
I'll give my perspective very quickly. We have a lot of tension at the Federal Public Defender's Office with kind of the gun libertarian groups.
I was wondering about that.
They're very distrustful of how we approach because they rely on the good guy with a gun versus bad guy with a gun distinction, and that's a distinction that we have to disrupt. The civil folks are the ones who win in the cases, almost always. So you look at Heller, you look at McDonald, you look at Bruen, those are civil people with guns, and that's a more sympathetic litigant. The criminals are unsympathetic, at least before Bruen couldn't win anything on these types of things. And so, me personally, I have no dog in the fight on the civil stuff. I think, I take the position, my personal position is that firearms are under-regulated and over-criminalized, right? Which polls at like less than 1%. It's kind of like being,
You're not gonna run for office on that.
yeah, it's like being for the war but against the troops, kind of. Anyway, I want to represent people who are facing the most severe penalties. I'm not going to shed a tear for someone who can't have an AR-15 in their living room. I worry about the person who lives in a high crime area, whose pretext stopped, who possesses a firearm to defend themselves because they believe like they have to, and then they end up in jail for up to 15 years. Those are the people that I think are suffering in this context. Now, there's enormous suffering that happens elsewhere with mass shootings and things like that. I'm not discounting that. I'm saying when I compare the civil person who wants to be able to have an automatic machine gun because it's fun versus someone who's going to jail for a long time, I have more sympathy for the person going to jail. So the civil people win, the criminal people don't, but I would not want to, I wouldn't represent a civil person. It's not interesting to me. I don't think there's anything at stake for me.
Anyone else want to comment on that question?
Just briefly, for me, I don't know if I have a dog in the fight. I just want clarity in the law. I think that is, as a civilization, as a society, we are all citizens here. Everybody should know what the rules of the road are. You know, I care so much about our system of laws and our society, and I just think it's hard to exist when people don't know who's on first. And the quicker we get there, whether it's civilly or criminally, it actually doesn't matter to me. At bottom, I just want to get to a point that we can all agree on and move on as a society as to what we want, what rules we want to govern ourselves.
Next question.
Yes. Robert Leiter of George Mason University. One of the things about Bruen and Heller is they haven't disrupted large swaths of area. So prosecutions under the National Firearms Act are going forward. There's no question that you can enhance sentences for using a gun, crime of violence. The things that seem to be under most tension are the possession prohibitors, which are also the things that are most constitutionally problematic because they ban possession in the home. I mean, just total ban on possession. And I'm wondering, I'm just curious for your comments on this, more of a comment that I'd be curious for your feedback on. I think in some ways it reflects what has become the criminalization of crime prevention. Because when I talk to people who are in the criminal law space, especially prosecutors, their fears are always, well, you know, we don't want to wait until either a crime has been committed or even an attempt has been in progress. That what these laws do are let us intervene in the cycle of violence very early. And so for prosecutors, they tend to be very useful from that end. But you know, in the old days, you had sureties, you had things that were either not criminal or quasi-criminal ways of handling crime prevention. It seems now that we've turned to a model of crime prevention with a bunch of inchoate crimes that are themselves extremely punitive. And I'd be curious for your thoughts on that.
I'll answer that one.
I've talked to that.
Yeah, I guess for me, I'll just speak as, you know, my perspective comes from the executive branch, and I am here to execute the laws. I feel like that's a great question for our legislature. And to say, like, you know, is that actually an effective legislative response to a public safety issue? And in my view, if the legislature say, no, that one's off the books, no skin off my nose, there's plenty of other things in the federal code to enforce. But I see your point that, you know, is that the right thing? I will say we do use it as you described. We do use it as a tool. I'll say, like, you know, we mentioned the MS-13 individuals. You know, those are often inroads to, you know, get people with charges. Maybe they decide to cooperate. Maybe that gets you further into larger crimes. So in some respects, it can be a doorstop into, you know, larger issues. But like I said, but for me, I think ultimately it's a legislative call, and if they decide that's what should be done, then I'll prosecute that.
Can I ask why on that one? Because there are a lot of crimes federal prosecutors don't enforce.
Well, I think
why is this a legislative?
Well, I'll say, like, I think we at least try to enforce, you know, all the ones that we see. There's certainly ones that, you know, we see more often and that we charge more prevalently. But I'm of the belief that if it's something that's on the books, we should be enforcing it when and if we can in our prosecutorial discretion.
This may be related to your question. So on the preventive side, we want to have these gun laws to prevent, it's a matter of policy to prevent bad things from happening. So I think one of the next critical challenges that's going to come up under Bruen is the red flag laws. And so are red flag laws going to be able to withstand scrutiny under Bruen? I mean, again, if we apply this test of looking at the historical, the history of gun control, is there an analog with respect to banning weapons from people that suffer from some mental illness or mental disability? You had commented, Kelly, that from a policy perspective, this is good policy, right? I mean, isn't it good policy? I mean, we actually permit individuals to be not saying locked up, but certainly detained, right, based upon involuntary detention if they pose a danger to society. But apparently those same individuals cannot be prohibited from possessing a gun under Bruen. I mean, that strikes me as being inherently inconsistent. But again, there is a Second Amendment that applies in the gun possession case. So what's your sense of how Bruen would what the outcome on red flag laws would be following the framework in Bruen?
Well, I'm going to say the thing that makes most people groan when I say it, which is it depends on a number of different factors. But before I get into that, I do want to say one thing about the extreme risk protection orders, which is they are not meant to be either exclusively or primarily a tool to address people experiencing mental illness. It's meant to address people who are dangerous to themselves or others for any variety of reasons, whether that be suffering from mental illness or a lot of different things. I think the extreme risk protection orders are maybe unique in the space of gun violence prevention in that they address a wide array of different harms, including self-harm, interpersonal violence, as well as mass shootings. They are primarily used for the prevention of suicide, but there is a growing body of research showing that the orders are sought based on threats of mass harm, so threats primarily to K-12 schools. It's almost like you'll have to do a couple of different parallel tracks for historical analogies for suicide prevention, but also historical analogies for the prevention of interpersonal violence, which I don't think is terribly that different from Rahimi in one respect, but somewhat different in a different respect. And to go back just a little bit and get on my soapbox, because why not? In terms of crime prevention, I don't necessarily think of the domestic violence protective orders as being particularly early down that road. Many studies show that by the time people are seeking protective orders, they've already experienced incredibly severe abuse. There's studies of women seeking protective orders who have experienced extreme violence like choking, strangulation, severe physical abuse. And so this is ultimately, in my mind, to prevent lethal violence at this point. And so that doesn't answer your original question, but I think, again, it depending on the level of abstraction, how closely. Obviously, there were no extreme risk protection orders at the founding. I think we use the word innovative to describe URBOs in almost every single thing we put out at the Center for Gun Violence Solutions, which isn't doing us a whole lot of favors right now. But I think the broader term goal, I don't think is dissimilar from a lot of the goals of historical laws.
Yes, sir.
It's Darryl Miller. So one of the things about the Rahimi case that I talked with my colleagues and sort of during lunch that perplexes me is like what's so special about the gun? So imagine you had a scenario where instead of having as part of the restraining order, you can't come within whatever, a mile or 100 feet or whatever of the person, or you can't see kids, or you can't call them up, or you can't do that. You just had a separate standalone statute that did the same thing. Just made it a crime to do these things. And then you have a process to figure out whether somebody is going to be subject to a restraining order, but the criminal penalties are out as a freestanding statute. That strikes me as exactly what this prohibitor does, right? You have a process, and then you have a freestanding thing sitting out there that says, now you can't have a gun. Now, it's not, you can't have any weapon. I'm assuming you can still have a club, you can have kitchen knives, you can have whatever, it's just you can't have a gun. So what work is the Second Amendment and the part of this case actually doing other than making it constitutionally safe? Because it feels like we adjudicate a bunch of other kinds of rights, you know, substantive due process rights, First Amendment rights in the DZ context already. What am I missing?
Well, I'll go unless somebody wants to go.
Go ahead.
You first.
I hope, this may not answer your question, but I'll give my best shot at it. If there was a domestic violence protective order that said you can't come within shooting distance of the applicant. So the goal here is to protect the person that's the survivor of domestic violence. And the way we're gonna do so is if a gun can shoot a mile or whatever, you can't come within a mile of that person. I think the Second Amendment gets implicated, at least under Heller and McDonald, when the prohibition extends to possessing a firearm in the home for purposes of self-defense. So there are examples where someone has a domestic violence protective order, moves literally to another state, and is then prosecuted federally for possessing a firearm in their home. That's where it kind of, the Second Amendment really comes more into play for me. I know Bruen extended that outside of the home, and that does complicate things. But I think a protective order consistent with even Rahimi winning could prohibit a firearm in the proximity of another individual who is an applicant for a protective order.
I think we have time for one last question. In the back, yes. Need a little louder, so we can all hear it front.
I'm just a 2L here at the law school. This question is best for the whole panel, but I think Mr. Manager might not care as much because I think for this question matter, you have to think that you can go beyond just a direct historical analog with the Bruen analysis. So assuming that you can do that you can do something akin to what Professor Beck suggested or what I think Professor Bode kind of alluded to, where you could kind of, you would look to the reason behind it. You say, oh, it's protecting from dangerous individuals. You have to check. There's a historical precedent for like dangerous individual regulation, and you look at 9th and UG in light of that. And if you're doing that, do you have this thing where it means an analysis kind of becomes a problem again? And it sort of slips back into, because everybody's kind of characterized it like, oh, we're done with the means and analysis, now it's a historical analysis. But then if your historical reason is like, say, dangerous individuals, then the statute becomes a proxy for like finding the dangerous individuals, and then you could easily see scenarios where it could be a very broad statute, namely if you have any sort of restraining order that you don't have the right to a gun, or it could be very narrow where you have to do an individual analysis for each criminal defendant in the prosecution and see like, are you really dangerous? And then it seems like there's sort of another means analysis where you're like, is the statute narrowly tailored to the interests that we have, even though it's sort of a historical analysis. So like, do you guys think that we're done with means end, or do you think it'll sort of sneak in again, even inside the like Bruen historical context?
Do you want to go, or do you maybe?
Go ahead. Kelly, do you want to say?
Could be anybody. I mean, I think it, in some ways, yes, maybe like a means end light. Because again, I'm not completely sure that Bruen is really fussed about whether it works, which was a really big part of the analysis under intermediate scrutiny and strict scrutiny. It was how closely was it fit to achieving this purpose. Now I think we're left solely with how it's done and why it's done. And so that's been a big question about the courts, is how do you determine if the touchstone of constitutionality is dangerousness? How do you determine today who is dangerous, and how much deference do you give to legislatures to determine who is dangerous? I mean, I think if you look at some of these historical laws, many of them were categorical proxies, right? People who refused to swear oaths of loyalty. Not necessarily an individualized assessment. And interestingly enough, the first version of the Fifth Circuit's opinion especially eschews this idea that an individualized assessment is appropriate in this context. They replaced it, I think, because of a lot of well-deserved criticism of that particular passage. But from our perspective at the center, I think that's exactly the place that public health research returns to the analysis, is determining who is dangerous, and maybe that's appropriate on a categorical level. Maybe the court will decide you need to have an individualized assessment, in which case perhaps in Rahimi what we'll see is an upholding of most but not all of 922G8, keeping the protective orders where there's this credible finding of threat, of danger to the intimate partner or their child, but not necessarily orders that just include these prohibitions on this type of activity. It's up in the air, everything else.
Let me just real quick, we're going to wrap up here in about 2 minutes, so any additional response? Either of you?
Well, I think means and scrutiny may come back. I mean, the government spends a good amount of its briefing. The amici spend a good amount of their briefing, speaking very accurately about the societal problems today that domestic gun violence presents. That's very, very true. But it's only really true, it only really matters in a means in scrutiny, right? When you're weighing the degree of governmental interest, for example. So to the extent at all the court latches on to some of that as persuasive, I think it will reincorporate some means in scrutiny to the analysis. Bruen, at least the Thomas opinion in Bruen, says none of that matters. I assume there are other justices on the court that may have even gone along with that do think it matters. So to the extent that I'm right in predicting that Rahimi will be approach narrowing the Bruen test, that's one way it can do it, again, to clarify and say we're not really doing means and scrutiny, but I think that's what it is when you start weighing the degree of the governmental interest.
Jason, you want to add anything? Last comment.
No, I'm good.
Okay. Okay. Then I would like you to join me in thanking our panelists for very rich and very stimulating and interesting discussion.